Can Indian founders be like Mark Zuckerberg? Well, yes, legally speaking, they can enjoy the legal protection that Mark enjoys at Meta. And due to this protection, nobody can fire Mark from Meta like Steve Jobs was from his own company Apple. And this is despite the fact that Mark only owns 13% equity in his company, but he owns something which is very interesting, and that's what we call as the superior voting rights. Now, firstly, understand that in India, the general rule is given in Section 47 of the Companies Act that provides that equity holders will have voting rights in proportion to the equity that they hold, which means one share is equal to one vote. But you can also do one share for 10 votes because Section 43 of the Companies Act does allow for issuing shares with differential voting rights. And this has been there for some time. But despite that, the Indian startups were not able to avail the benefits of this because this was regulated by Rule 4 of Company Share Capital and Debenture Rules 2014, which provide that the company has to have profit for the past 3 years. Now, in most cases, Indian startups were not 3 years old, or if they were 3 years old, they were loss-making companies like most startups are because they focus on growth stages. But this condition has been done away with by the government in the year 2019, which makes it much easier now to issue differential voting rights to the founders. So if you are a founder running a startup and you want superior voting rights in your favor, you can certainly have that. And this is the legal insight for this video. If you like this legal insight, consider following for more.